We're ready to proceed. This is State versus Richard Evans, and each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes.
Thank you, Your Honor. And I would like to reserve 5 minutes for rebuttal. Thank you, Judge Carr, and esteemed panel. I'm Patrick Brown. I represent the appellant Richard Evans. And Your Honor, this case, let me start by saying this is a difficult case. Melanie Wickens lost her life in this case. And these cases are also difficult, but I think what we're here today is to decide the legal issues. And there's a couple of important related issues in this case. Number one, can the state introduce a death certificate without any expert testimony to testify about the cause of death? And number two, was counsel ineffective in this case for failing to conduct a reasonable investigation, specifically failing to consult with experts on the crucial issue in this case of intoxication? Let me start with that second issue.
Could I ask you a question
Sure.
about your objection on the death certificate? Is
Sure.
it not an official document? And what is your particular concern about relying on that document?
Well, Your Honor, it is an official document, and the Supreme Court in State v. Maxwell held that it's not testimonial, and it does fit a hearsay exception. I think the issue is introducing a document that effectively has medical evidence, in this case, stating what the cause of death was. In this case, it was blunt force trauma, without any kind of expert testimony to explain, in this case, what blunt force trauma is. I mean, something like blunt force trauma, or even in a more complex case. Yes, okay.
And I want to follow up, because I was going to ask a similar question.
Sure.
And that is, okay, let's say that it shouldn't have been introduced and, you know, it contained hearsay and all these things. How were you prejudiced?
Your Honor, in this case, I acknowledge that the cause of death was probably pretty clear, so the error may be harmless in this case. I think that, I mean, there's no doubt that Mr. Evans caused the collision, and this
That's what I was getting at.
died as a result of that. What we're really looking for is the rule of law in this case, that the state can't just introduce a death certificate without expert testimony to testify about the contents of that, what blunt force trauma means. The court may conclude the error was harmless on that issue. I think the bigger issue in this case, Your Honor, after going back and reviewing this case, is the ineffective assistance for trial counsel failing to consult with an expert on the issue of intoxication. Let's start with the fact that trial counsel knew that the state was going to present an expert, Dr. Wyman. He would have had the expert report, who was going to testify. Mr. Evans' BAC was .094 at the time it was taken, which is just slightly over the legal limit. The state then presented the testimony of Dr. Wyman, who testified at the time of the collision, which is the relevant time. His BAC was .165. In other words, the BAC was going down between the time of the collision and the time that the blood was taken. I think on the facts of this case, Your Honor, there was a strong argument to be made, given the fact that Mr. Evans ate food shortly before the accident, and there was evidence that he consumed alcohol after the accident, that his BAC was actually rising between the time of the collision and the time they took his blood, which would have been his peak BAC. But you can't make that argument. Trial counsel couldn't effectively make that argument without consulting a toxicologist, presenting the facts of the case to a toxicologist, and if he had done so, trial counsel could have presented a defense that Mr. Evans' BAC was actually under the legal limit at the time of the collision. That is, it was rising between the time of the collision and the time that the blood was actually taken. Trial counsel, at the very least, should have consulted a toxicologist to see if that was a viable defense. I mean, the case, the most serious charge in this case, the aggravated vehicular homicide, which carries 8 years, hinged on whether the state could prove that Mr. Evans was intoxicated at the time of the collision.
How can we be sure he did not consult a toxicologist?
Well, I think from the record, Your Honor, this is a court-appointed case. No funds were requested to consult with experts. So I don't know how trial counsel, I mean, he wasn't spending his own money, Mr. Evans wasn't putting up the money, without requesting funds from the court. And that's something we can glean from the record. There would have been no way to consult with an expert without money. I mean, you can't effectively give the case to an expert without paying them. So if trial counsel, and you can look at trial counsel's fee petition, and there's no motion for the court to release funds for an expert. If we look at all that, I think we can infer with a great deal of confidence that he did not consult with any experts, because he didn't request any funds to do so. So if we take as a given that he didn't consult with a toxicologist, there's two questions for this court to consider. Number one, was that performance deficient? And there's a number of cases, starting with Strickland, that says counsel has a duty to conduct a reasonable investigation. The federal circuits have consistently held, the Sixth Circuit, the First Circuit, and I actually found a case, Your Honor, that wasn't in my brief, that I found in preparation for this oral argument today.
And you know that our local rules say you cannot use that in your argument unless you actually file a motion to supplement.
And Your Honor, I just found this yesterday in all candid, and I would like to make an oral motion to supplement, or if the court would allow me to file a written motion to supplement, because I think this authority is important.
Well, two things I would say. One, you do have to do a written motion.
Okay.
The reason is, and I hate to take up your time, but the reason is because he shouldn't be blindsided.
I agree with
You know,
that.
that's the whole point. That's
So
the reason why
I'll
we
put
have
that in
it.
the form of a written motion.
Why don't you
But
file a written motion?
Strickland has the applicable standard, Strickland versus Washington, and that's the binding authority that counsel has to conduct a reasonable investigation. I don't think it was reasonable in this case to not consult a toxicologist on the key issue of what was Mr. Evans' BAC at the time of the collision. I mean, if you look at the facts, his blood was drawn, I think, 4 hours after the collision. So you really got to determine through expert testimony what was his BAC at the time of the collision. Counsel didn't do anything in the way of consulting with a toxicologist, which if Mr. Evans' BAC was actually rising and his BAC was actually under the limit at the time of the collision, it would have raised reasonable doubt as to the aggravated vehicular homicide. The section that is based on whether he was intoxicated. Certainly, I think, given his speed in this case, the state can confidently argue that he was reckless. But we're talking about the difference between a felony of the second degree and a felony of the third degree.
I was a little perplexed by the briefs regarding the testimony about the amount of time that the brake was applied, because it seems was some testimony that it was 5 seconds, and there was some testimony that it was 1 second. I'm slightly confused by that. Maybe just a typo in the brief, but.
Yes, and I think it probably was unclear during the trial about what actually happened. I think the state's expert, Lieutenant Team, or Tem, I think it was, testified that he read the airbag module and it indicated the car decelerated from 60 miles an hour to 29 miles an hour in a matter of 1 second. It indicated the brake switch was on for 5 seconds. I mean, I'm not an expert on this stuff, so I think there is some valid confusion on that issue. And that would have been a reason, I think, for trial counsel to consult separately with a mechanic as an expert to look at that. So that's another issue for this court to take up.
And was trial counsel able to cross-examine both the toxicology testimony regarding blood alcohol and the testimony regarding the car mechanisms? Was he able to?
He was able to cross-examine, but the cross-examination, if I remember from the transcript, was fairly brief. And it's not going to be as effective as if you present a toxicologist to testify for your client that the BAC was actually under the limit at the time of the crash. Sure, trial counsel had the opportunity to cross-examine the state's expert, Dr. Wyman. And I think he even asked him, did you take into account these certain factors, that he ate food, that he consumed alcohol after the accident? He probably asked him those questions. But he really should have consulted with a toxicologist to see if he could raise what's called a BAC on the rise defense. That .094 was in fact his peak BAC, and that at the time of the collision, the BAC was actually under the legal limit. That wasn't done, and it's really hard to get that kind of evidence in through cross-examination. You're not going to get the state's expert to deviate from his opinion, which trial counsel would have had in advance, that the BAC at the time of the collision was .165. I don't know how you effectively, through cross-examination, raise a BAC on the rise defense, or raise the possibility that the BAC was altered by consuming alcohol after the crash. I really think trial counsel, at a minimum, should have consulted with the toxicologist, and I think that his performance was deficient by not doing so. So then the court has to reach the issue of prejudice. That's obviously the trickier issue in these ineffective assistance of counsel cases. Was Mr. Evans prejudiced by his trial counsel's failure to consult with a toxicologist? facts in this case that would indicate that a BAC on the rise defense was viable, and the two facts are this. Number one, Mr. Evans consumed food shortly before the accident, which causes alcohol to release in your system in a delayed manner, meaning that his BAC still could have been rising between the time of the collision and the time his blood was drawn. Number two, the fact that he consumed alcohol after the accident. Those two facts raise serious questions about whether Dr. Wyman's testimony that Mr. Evans' BAC was 0.165 at the time of the collision was accurate. If trial counsel had consulted with the toxicologist and given those facts, I'm sure he would have been able to find one to come in and say that Mr. Evans' BAC, to a reasonable degree of scientific certainty, was actually rising between the time of the collision and the time his blood was drawn, such that he was under the legal limit at the time of the collision. If you present that kind of testimony, that raises reasonable doubt, and I think there's a sufficient probability that the conviction on the F2 aggravated vehicular homicide would have been not guilty.
Counsel, you're in your rebuttal time.
Okay. So thank you, Your Honor.
Thank you.
May it please the court, Mr. Brown, Nathan Shaker on behalf of the appellee of the state of Ohio. Now, since we are focusing on the issue of ineffective assistance of counsel, I don't believe this case makes it past the first prong of Strickland versus Washington. Trial defense counsel's performance did not fall below any common standards when you look at the evidence that he was presented with. Trial counsel was presented with police reports where his client denied driving. At page 515 of the transcript, Mr. Evans states that, yes, I told the police officer I wasn't driving. He also told the insurance agent who testified at page 526 of the transcript that he wasn't sure he was driving. These statements essentially hamstrung defense counsel, and defense counsel did what he could with the evidence. Retaining experts and looking at the BAC would, at that point, prior to trial, would require an admission to driving. I don't know what his conversations were with his client, but what his client had told police, what was documented in the discovery provided to defense counsel, would be that Richard Curtis Evans denied operating the motor vehicle. So defense counsel's performance met every objective standard. The cross-examination was effective. He effectively cross-examined Dr. Wyman regarding the contents of the stomach in terms of if Mr. Evans had actually ate food, if that would have changed the amount of alcohol that was eliminated from his system. But also the issue of BAC is not, the blood alcohol content is not completely determinative of this case. This was charged as aggravated murder under 451119. We were going after A1A. The OVI charge that was attendant in the indictment was an A1A charge. So we're looking at whether he was under the influence. We're not going for that per se level, obviously. So we had seriously impaired driving 71 miles per hour on a 35 mile per hour road that is extremely hilly in a residential area, losing control of the vehicle. So defense counsel's judgment in not retaining experts was completely sound given that what he was presenting. So I don't believe we even get to the prejudice portion of the Strickland test.
Did he, the defendant, did he testify?
The defendant did testify.
That's what I thought. So he testified he was driving.
He testified he was driving, but he also testified that, page 515, he stated that he told the police that he wasn't driving.
That he wasn't?
He was not driving.
Right.
So what defense counsel would have received in discovery was a police report where his client denied driving. That really does hamstring a defense attorney, and you can understand why he did what he did and why he chose to focus on this drinking after, because that's what came up at the time of trial when the defendant took the stand. So I believe we don't even reach the second prong. The first prong is determinative.
Why is this not PCR?
I'm sorry?
Why is this not PCR material?
PCR, I'm sorry, I'm not familiar.
I'm sorry, post-conviction relief, I apologize.
Okay, that, I guess that could at this point in time.
Because, and I'll ask him when he
Sure.
comes up for rebuttal, but let's say he should have done all this, without having anything in the record to demonstrate that that was a viable defense and this would have been the result.
That very well could be. I mean, again, it wouldn't be appropriate for this court, but I don't know what is out there in terms of the malfunction. That wasn't brought up. That was never said. Mr. Evans' wife, I believe in her statements to police, and even her testimony, she was the owner of the vehicle. She never even mentioned any kind of malfunction. So the defense attorney worked with what he had to. He put the witnesses on the stand. The story somewhat changed from what I assumed he expected. In terms of the other assignments of error, obviously the emphasis on the birth certificate, I do believe that it was properly admitted pursuant to 8039. I also believe that the coroner's physiological causation comes in under 313.19, and as Mr. Brown alluded to, any error in that regard would be harmless because it was clear. But there was, beyond the coroner's physiological determination, there was plenty of evidence of legal causation, and that's what I believe what Mr. Brown had alluded to being harmless error. It was clearly clear that there was a car accident and that Mr. Evans was the driver. With that being said, the state correct.
Thank you.
Thank you.
I know you have plenty to say, but I'll start you
Sure.
off with why isn't this PCR material?
And I think it could be really raised in the post-conviction relief proceeding. Mr. Evans is obviously indigent. I was appointed to handle his appeal, so this is
Yeah.
the avenue. we
Well,
have
you
at
may
this
not
point.
have the ability, I don't know,
Right.
you know, but I'm just wondering because it just jumped out at me that why, how, even if your argument is correct, how do we get past that we don't have any evidence? Since, like you said, he didn't consult with an expert. Whereas with the PCR, obviously, he'd be able to consult with an expert and then put evidence in the record
Sure.
that, you know, the blood alcohol was rising.
Right, well, and that's true. I guess that's the problem with not consulting with an expert is it leaves the record somewhat void. I mean, if this court concludes that it was unreasonable under Strickland for trial counsel to fail to consult with an expert, then it has to reach the issue of prejudice. I think that's what Your Honor's driving at. How do we find the issue of prejudice without additional information? There were facts in the record that could show that the BAC on the rise defense was valid. I think I mentioned the food and then consuming alcohol after the accident. To answer your question, Your Honor, I don't know. This is the avenue Mr. Evans has at this point. I wasn't appointed, and I don't even know if attorneys can be appointed to handle post-conviction proceedings. All we're really asking for, Your Honor, is I'm sure that the state would argue that they can prove recklessness and the F3 conviction can be sustained, and I can't quarrel with that. We're just asking for a new trial on the F2, the aggravated vehicular homicide based on intoxication, so that Mr. Evans has the chance to consult with the toxicologist and raise that defense. We're talking about the difference between 3 and 8 years in prison. So we're just asking for a new trial on the F2, Your Honor. Mr. Shaker raised a couple of points. Number one, Mr. Evans had denied initially to the police that he was driving. At the time of trial counsel knew he was going to put Mr. Evans on, and he knew that Mr. Evans was going to admit to driving. He would have prepared him. So he would have known that that wasn't going to be an issue at the time of trial, even if initially Mr. Evans had denied to the police that he was driving. At the time of trial counsel would have been fully aware that Mr. Evans was going to get on the stand and admit to driving. So trial counsel would have been aware of that fact. He should have consulted with the toxicologist. He did not. So we're asking for a new trial on the F2 to give Mr. Evans a fair opportunity to consult with the toxicologist and raise that BAC on the rise defense. And I thank the court for its time.
Thank you.
Thank you.
Gentlemen, I'm sorry.
Yep.
I would like to commend the both of you for your arguments on the plain error assignment. Many times this court will receive a plain error assigned error, and then plain error will not be argued, and will not see the law related to that. And both of you did, it was a very good job. setting forth the law, which of course is important if that's what you're saying is error. So it was noted, it was duly noted.
Thank you.
We appreciate it.
Thank you, gentlemen. Thank you both for your arguments to the court. The court will take the matter under advisement and will issue a written opinion that will be sent to both of you,
Thank you.
as well as the court will release on our website. All right, thank you.